Ready, start. This OP is filed by a Christian husband to declare his marriage with the respondent is a nullity under Section 19 of the Indian Divorce Act. The petitioner married the respondent on 8 to 1987 in accordance with Christian rites and ceremonies. It was an arranged marriage. After marriage, they lived together in the house of the petitioner for 3 days and thereafter in the house of the respondent for 3 days. Subsequently, they went to Indore. The petitioner has contended that after 4 weeks of living in Indore, the respondent showed signs of mental illness and therefore she was taken to a homeo doctor at Indore who said that she may be suffering from homesickness. The parents of the petitioner was informed and her mother, father and sister went to Indore and gave some medicines to the respondent. When the condition of the respondent was improved, the father and sister returned first. Subsequently, the mother also returned. Again, she became ill and she insisted that she should be taken back home. The petitioner took the respondent to the native place in train. While traveling in train, the respondent informed the petitioner about her mental illness and treatment by Dr. Ramachandran in Thiruvananthapuram much prior to her marriage with the petitioner. The petitioner contended that after reaching the native place, it was confirmed by the consulting the doctors that the respondent was suffering from mental illness and she was undergoing continuous treatment for illness before and at the time of marriage. According to the petitioner, the respondent and her relations played deliberate fraud upon him in not disclosing the mental illness of the respondent to him before the marriage. Therefore, he contended that his consent for the marriage was obtained by the respondent and her relationship by playing deliberate fraud upon him. He also contended that in case he was informed of the mental illness of the respondent, he would have not consent for the marriage. Therefore, he sought for a declaration of his marriage with the respondent as a nullity under Section 19(3) and proviso to Section 19 of the Indian Divorce Act on the ground that the respondent is insane and his consent for the marriage was obtained by playing deliberate fraud upon him. Para. The respondent has contended that she is not suffering from any mental illness and she has suffered a mild mental depression when she did not succeed in the getting an employment after her graduation. Hence, for that she has consumed a very small dose of medicines. According to her, she was completely cured of illness thereafter, but when she went to Indore along with the petitioner after marriage, as she was far away from her native place, various difficulties arose. According to her, the climate and food habits were changed. There was no servant to assist her. She was in an early stage of pregnancy. Her parents and relations were far away. Nobody in Indore knew her language and therefore she had suffered some mental anxiety. She suffered further contended that the petitioner, without taking her to the psychiatrist and gynecologist, took her to the homeo doctor who said that she may be suffering from homesickness. She further contended that she is not suffering from any mental illness and there was no mental illness before or at the time of marriage so as to enable the petitioner to claim nullity of marriage under section 19(3) of the Indian Divorce Act. She has also contended that absolutely no fraud is played by her or her relations in obtaining the consent of the petitioner for the marriage and therefore the petitioner is not entitled to claim a decree for nullity of marriage on the ground of playing fraud in obtaining his consent under the proviso to section 19 of the Indian Divorce Act. Stop.